I'm joined by Harry Littman from the Talking Feds YouTube channel and the Talking Feds podcast. Hey, Harry, Donald Trump is clearly terrified about this September 18th sentencing date, and he's tried everything right now to derail that from taking place, including trying to remove the state criminal case where he was already convicted on 34 separate felony counts to federal court. Federal Judge Hellerstein rejected it first on technical grounds that Trump did not attach the certificate that either an agreement from the district attorney was reached or a judicial finding by Hellerstein was made that there was good cause to even attempt to remove the state case based on where it was in terms of the proceedings already getting to a jury verdict to federal court. Judge Hellerstein then said there's not good cause, essentially strike two by Donald Trump after Trump tried it again and cured the technical deficiency. So now, after being rejected within days by the same federal judge over and over again, of course, Donald Trump took an appeal to the Second Circuit. But ultimately, I want to get your take. For me, it seems like this is a transparent play to try to get before the Supreme Court to call on the right-wing justices he appointed to try to stay or stop the criminal sentencing from taking place where he's been convicted. And there's this cat and mouse and cat game, if you will, taking place where the district attorney's office then sent a letter to Justice Merchan saying, look, there's no reason at all why anything should be stayed right now. Judge Hellerstein rejected Donald Trump's attempt to remove this proceeding, found there was no good cause. Let's just move forward, Judge, and you'll still have the discretion about whether or not the sentencing should or shouldn't take place or what you're going to do there. But we need to get the show on the road here. I want to get your take on it because just so many filings over so many different issues. But basically at the heart of it, right, is Trump not wanting the sentencing to go forward. What do you make of it, Harry?
You know, so I think that is right, 100%, and even a little more calculated than you say. There are a lot of filings, but they really always repeat the same stuff. This removal, which was, as you say, his second strike and his second attempt, he did this before the trial took place, goes to Hellerstein and says two things. It says, the same old tired, the judge was biased against me because his daughter works for a consulting firm that did some work for Kamala Harris in 2016. And then second, he tries to make the removal argument that he was acting under color of office. As to the first, well, the whole thing Hellerstein gave really back of the hand treatment to. On the first, he said, look, that's a state court issue. That's not for me. But on the second, it was interesting. He very quickly just said in about a sentence, nothing here because, as I've held before, when you're paying hush money to a porn star, you're acting unofficially. And it really reinforces, Ben, the difference between, removal and immunity. We've been dealing with different versions of a similar argument, which is Trump trying to say he's acting presidential when he's doing all this stuff. And there's removal, and there's will the DOJ represent you, and there's immunity. But basically, Hellerstein said, look, this is about, he gave it the, generic kind of description. It's accurate. It's about trying to pay hush money to a porn star. That's nothing presidents do. He wasn't even president at the time. So we don't have the hang up that there is in the immunity question, because remember, the Supreme Court took that extra step in immunity and said, you can't even use evidence that could be of immune conduct. And that raises this problem for the trial in New York. Was the conversation with Hope Hicks when he was president itself immune? But that doesn't come up on removal. Why I'm saying it's even more thought out and concentrated for Trump here, I think you're exactly right. The play is to the U.S. Supreme Court, and it's all about September 18th. So I think he's calculated in his mind Hellerstein would give him quick a quick denial. Now he's in the Second Circuit. I think he doesn't think the Second Circuit will rule for him. If it does, that's fine. It's all about a stay, by the way. He wants the sentencing not to happen. So if they rule against him, now he goes to the Supreme Court. And if you do the math, it's not exact, but basically it gets to the Supreme Court maybe a couple days before September 18th. And if they enter a stay on their shadow docket, his very friendly confines at the court, then September 18th is off the docket, and it'd be really hard to put the pieces back together again, even if the Supreme Court denies relief, to get it off again before November 5th. So his play here is not simply to just throw anything against the wall twice and see if it sticks 3 times, but rather to time it so that his familiar and welcome territory on the Supreme Court actually intervenes in the perfect timing to keep Merchan from sentencing on September 18th. That's my take on this.
I want to give our viewers and listeners, a warning, if you will, but anticipate the steps. You mentioned the shadow docket. So when you file that emergency petition to the Supreme Court, it gets assigned to the Supreme Court justice who oversees that specific circuit. Second Circuit is Justice Sotomayor, who was appointed by former President Barack Obama. What we may see happen, which may surprise people, but it's just worth seeing how the Supreme Court's been operating on anything kind of Trump related or high profile and controversial. We've sometimes seen that Supreme Court justice who oversees the circuit issue a kind of temporary stay, refer it to the full court, and then the full court ultimately determines how it's going to exercise or not exercise discretion under the kind of shadow docket power. So there may be a headline that comes out that Justice Sotomayor,
right. Although it would only be for I'm sorry, go ahead.
No, and so that's a possibility of what could happen. So I just wanted to flag that issue for our listeners and viewers.
Now, it would only be for a day, and then it would go to the full court. But, we just had an election law case. I won't go through it all with your listeners. But again, it sure seemed like this wasn't worthy of relief, and they didn't give it. But Alito, Gorsuch, and Thomas all voted for it. So if he gets up there, look, it would be a mini version and a mini outrage, as the immunity case was a maximum outrage. When, remember, it's not just the opinion, but that they intervened last December and kept it until July. So to keep Trump from having any accountability now during that first term. I'm not saying that's precisely why. I'm not saying it's not, but the idea that they could, just by, granting a stay or their shadow docket, basically do what Trump really, really wants, which is no sentencing before the election. Remember, when the conviction itself happened, the 34 counts, there was a definite downtick for him, and it's hard for him to get downticks because everybody has an opinion about him now, and it's fixed. He lost support after that New York conviction. If Merchan gives him a sentence, and he won't put him in jail during the election, but if he announces one and it brings home that he's a 34-time convicted felon, they're very worried about the political consequences of that. So he's bobbing and weaving and doing whatever he can to keep that from happening. And that means for Trump, get it to the Supreme Court if you possibly can.
One of the ways you can tell how afraid he is if you look in the other case, the Washington, D.C. federal criminal case, where Donald Trump had the opportunity to waive his appearance on the superseding indictment or try to turn it into a publicity stunt to get attention. He opted for a waiver of the appearance because he was already indicted, a year ago on the original indictment. So it shows you that he really doesn't want anything to do with these criminal cases. and wants to really keep his distance from that. It'll be interesting to see what the Second Circuit does. I mean, we're talking about hyper-technical legal issues. Judge Hellerstein found that there was not good cause for the removal to happen even before the Manhattan District Attorney could have then countered with a request that the matter be remanded, have an evidentiary hearing, and have full briefing. So we could get really in the weeds on a technical issue about whether a good cause standard was reached, thus kind of shifting the burden back to the district attorneys to then try to have the matter remanded, and whether that should have taken place. I think we can expect that's what Trump and his lawyers are likely going to argue before the Second Circuit and then ultimately before the Supreme Court. But all of these things that you and I are saying, it's just kind of pretext and subterfuge for he wants delay. He doesn't want the September 18th date happening. And he's going to throw everything underneath the you-know-what to try to make that happen. So everybody...
Just a very quick point. That's why the DA knows his game. It's all about a stay now. And in theory, you grant a stay just to freeze the linebackers, and you can then decide this is all about the stay. That's why the DA goes to Hellerstein. No stay here, please. And that's exactly going to be the focus of the parties, not how this eventually comes out.
We will keep everybody posted. Make sure you subscribe to the Talking Feds YouTube channel. It's where I go to get my legal news. And so if you want to know where I find out about this stuff, it's from Harry Littman, who's got experience like no other out there. Make sure you subscribe. Talking Feds YouTube. Thanks, Harry.
Thank you, Ben. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.